Mr. Dennis Tan.
Mr. Chairman, recently, Kappa was given a combined total penalties of $422 million in US, Brazil, and Singapore arising from their acts of corruption in the Petrobras bribery scandal in Brazil. Presently, anti-corruption policy seems to be something of an afterthought in Singapore Inc. Disclosure of the existence of an anti-corruption policy by public-listed companies is startlingly low. According to Associate Professor Lawrence Low's findings on the Singapore Governance and Transparency Index 2017, it seems that out of 606 listed companies surveyed who had released annual reports for their financial years ending 31st December 2016, only 8.7% had disclosed relevant policies and practices relating to anti-corruption. Does this reflect the general attitude of companies towards anti-corruption policies? It is startling that the existence of bribery contracts and payments somehow seem to have escaped the notice of Kappa's senior management, board of directors, audit committees, and external auditors for 14 years. Could this point to the weaknesses in our current company and auditing regime? The Code of Corporate Governance requires, among other things, audit committees to review the policy and arrangements by which persons may raise concerns about possible improprieties and ensure that arrangements are in place for such concerns to be raised and independently investigated and appropriate follow-up action to be taken. However, only listed companies are required to follow the Code of Corporate Governance. In any event, SGX rule only requires listed companies to comply with the Code of Corporate Governance on a comply or explain basis. It's timely for the government to review and enhance its existing company regulations. All listed companies should set out appropriate policy on anti-corruption measures and other improprieties. The government should consider having inspections and subject non-compliance to penalties on the shoulders of companies, directors, and audit committee members. The government should also review and enhance the requirements for whistleblowing policies in companies. The government should also consider enhancing the requirements of the independence of the board. In Norwegian company law dictates that when a company has controlling shareholders, the independence of the board is principally intended to protect minority shareholders. This is a principle we should consider. For example, an independent director in our government-linked company should have no past or present political affiliation to the ruling party or occupational affiliation to the public service. The government should also review the Prevention of Corruption Act to consider if it is sufficiently adequate to fight modern forms of corporate corruption today. It is not as easy to successfully prosecute corporations as opposed to individuals under the PCA due to the way that the legislation is framed. The OECD Anti-Bribery Convention recommends the establishment of liability of legal persons for the bribery of foreign public officials. Should we not expressly include the offense of bribery of foreign public officials by both individuals and companies in the PCA? Finally, the government should consider adopting a failure to prevent bribery offence similar to Section 7 of the UK Bribery Act 2010. Such a measure would effectively impose a duty on businesses to enact adequate procedures to prevent persons associated with the business from committing bribery. Jurisdictions like Australia are also considering introducing Section 7 type offences into their own anti-corruption legislation.